Hi, I'm Rachel Howie, the co-lead for Dentons Canada's National Litigation and Dispute Resolution Group.
Hi there, I'm Matt Diskin, partner in our Toronto office in the Litigation and Dispute Resolution team. In our recent report, the Shifting Tides of Cross-Border M&A, Dentons, and together with the research provider Merger Market, surveyed 150 senior executives that have been involved in cross-border and global M&A transactions to see how these executives view the market. And as part of that survey, the respondents were asked about their use of dispute funding in M&A-related disputes. So dispute funding is money that's put up by a third party to finance the legal costs and sometimes the indemnity and downside costs of a dispute in exchange for a return on those funds. And the rising cost of disputes, and combined again with the pressure on legal budgets that exists, means that there's an ability to share or spread the risk, if you will, and the financial burden of pursuing claims, which can of course be expensive, with a third party, and that's really becoming much more and more prevalent and more attractive. And that's actually happening even to companies with strong balance sheets and good cash flows. So third-party funders, they comprise different models. There's different ways that they approach this, but they're increasingly public entities, as well as private entities that are investing in legal claims. And they've got a lot of experience in infrastructure and teams that do diligence on these cases. They investigate. They've got sometimes their own financial and other experts, and then structure agreements that make business sense. And they're very attuned to spotting the issues that can arise when you're looking at a claim, or often in transactions in a group of claims. So the decisions that these third-party funders have to engage in is they have to put the investment through the underwriting process, a committee, depending on the nature of the organization. It's usually sort of a global board of judges, lawyers, experts, senior folks, if you will, and they assess both the financial risk that underlies the case and its merits, its prospect of recovery. So coming into it, what companies, claimants really are looking at is there a sound theory of the case? A sound damages theory is very important. A sound recovery plan, very important. And on top of all of that, what's it going to cost? What's the budget? What's the expert cost going to look like? Who's the claimant? Nature of the claimant? Who's counsel? Are they competent? What's their experience in the area? And then evaluating that matrix, they'll come up with an approach, hopefully, to assist de-risking parties in high, usually almost necessarily high-value disputes.
While third-party funding was traditionally suited to claimants with single high-value claims and to defendants or respondents with counterclaims, the market has expanded in the last few years to include portfolio and other finance options for companies and for law firms. Within the range of different third-party funding arrangements that can be employed, the most common arrangements typically see either the funder and the client, or the funder and the law firm enter into a financing arrangement whereby the funder pays for all or a majority of the legal fees to pursue the claim, including expert fees, disbursements, and if applicable, tribunal fees. This is no recourse funding, and the funder's return on its investment is a share of the litigation proceeds, if any. The exact return sought by a funder can be highly negotiated and depend upon the costs and risks involved in funding a dispute. Respondents of our survey indicate that the use or consideration of the use of litigation funding to finance M&A-related litigation is on the rise, with 65% of respondents in the US and Canada and 53% of respondents in other parts of the world saying that they have engaged a disputes funder in the last 12 months. This rise in the use of litigation funding points to those involved in M&A transactions looking to further de-risk potential disputes. To learn more about protective measures that mitigate against unwanted deal outcomes and what to do when disputes arise, click below to read our report and contact a member of our litigation and dispute resolution team to discuss how we can help you protect your interests.